Good afternoon. I'm Leonard Baynes, the Dean of the University of Houston Law Center. I want to welcome you to the next panel and thank you so much for being here today. So the next panel will be looking at the LSAT and US news and socioeconomic issues. And we have an august panel with me. But before, I want to talk a little bit about what the origins of this panel were. And several of the panelists have been panelists before at the SEALS conference in Florida a few years ago. And one of the things I mentioned earlier today when I opened the conference is that we still have a significant underrepresentation of African Americans in the legal profession, even 70 years after Heman Sweat was rejected by UT Law School, solely based on his race. And as was noted in earlier panels, we only still have about 5% of lawyers in the nation are African American. Less than 8% of first-year law school students in 2019 were Black, whereas 13% of the population, US population, is Black. And there's a significant interest in African Americans and other minorities, Hispanics, Latinx, and others about going to law school. That's what the Before the JD project indicated to us. And a study highlighted that 60% of students report that they receive advice from their about going to law school, graduate school, and law school comes from family members or relatives. And many students from low-income backgrounds do not have family members who are lawyers and are at disadvantage about going to law school because they may not be encouraged by those close family members, or they may not be given appropriate advice. A Columbia Law School study from about 10 years ago showed that a majority of African-American law school student applicants were rejected from every law school to which they applied, as compared to only 34% of white applicants. Some scholars have argued that there's a strong bias or strong tie between socioeconomic factors and law school admissions. About 3 years ago, there was a very passionate discussion on Twitter discussing this issue by Law Prof blog. Some believe that the LSAT, on the other hand, some believe that the LSAT and US News privileges those from middle and upper middle class backgrounds. Others point out that the LSAT is strong, providing an accurate assessment of core skills required for success in law schools, and that admissions process that correctly uses the LSAT as one factor in a multi-factor holistic admissions process is the fairest to applicants. A few years ago, US News attempted to reduce economic privilege in its rankings of undergraduate schools by injecting socioeconomic factors. The formula now includes indicators meant to measure social mobility. The question that this panel will discuss is principally, and not principally, but one of the things that we'll discuss is whether consideration of socioeconomic factors should be injected in US News best law school rankings. The panel experts will examine each of these issues, including the LSAT, US News, use of socioeconomic factors in rankings, bar exams, and racial disparities. Moreover, given all these factors, the panelists will also consider what deans and law school administrators can do to enhance minority admissions. So we have a really august panel. Each will speak for about 10 minutes, and then we'll have a roundtable discussion. Let me introduce all of the panelists first. So first we have Paul Caron, who served as a Duane and Kellye Roberts Dean since June 1st, 2017 at the Pepperdine Caruso School of Law. Prior to taking the helm at Pepperdine, Dean Caron was Associate Dean of Faculty and the Charles Hartsock Professor of Law at the University of Cincinnati College of Law. Dean Caron has twice been named the third most influential person in legal academia by national jurists, and a dozen times has been named one of the 100 most influential in tax and accounting by Accounting Today. He is the publisher and editor of the Tax Prof blog, the most popular legal education and tax blog on the internet. He's published more than 50 books and law review articles. He received his AB from Georgetown, graduating magna cum laude, and before receiving his JD from Cornell Law School, also graduating cum laude. He earned his LM in tax from Boston University. Let's welcome Paul Caron.
Thanks so much for having me, Len.
And I'll introduce each panelist before they go on. So let's start with Paul.
Thank you so much for having me, Len.
Thank you. So why don't you start? I'll introduce each panelist before their presentation, if that's okay.
Great. Thanks for having me again. As Len mentioned, this is my 4th year as Dean of Pepperdine Caruso Law School. In my 10 minutes, I would like to give you a Dean's perspective on the challenges that we face in trying to increase both the diversity of our student body and the US News ranking of our law schools. I will end by offering some thoughts on how we might better align these two goals. First, I want to focus on the data. I want to thank Kellye and LSAT for sharing their data with me, much of which will be published on LSAT's blog and on my blog in the coming days. One thing that is important to understand is the difference between single reporting and maximum reporting. The Office of Management and Budget for many years has required single reporting of race and ethnicity for federal reporting purposes. In contrast, since 2010, LSAC has used maximum reporting. There is a difference in these approaches when an applicant self-identifies as 2 or more races. I want to use a simple example to illustrate the difference. Let's assume we have 2 law school applicants. A is white and Caucasian. B is Black, African-American, and Asian. In single reporting used by OMB, A reports as white, B reports as 2 or more races, for a total of 2. In maximum reporting used by LSAC, A reports as white, B reports as both Black and Asian, for a total of 3. I will be using maximum reporting in these remarks. I would be more than happy to talk about the differences between single reporting and maximum reporting in the Q&A. Next, I want to talk about race and ethnicity by LSAT score bands. This slide shows the distribution of LSAT scores by race and ethnicity in 2019. Green is the top 160 to 180 band. Orange is the middle 150 to 159 band, and blue is the bottom 120 to 149 band. The green and orange bands are higher than blue for white and Asian applicants. Blue is higher than green and orange for Black and Hispanic applicants. This slide shows the total applicants for the past 8 years. Applicants declined in 2013 through 15, but have steadily increased over the past 4 years. It looks like this increase will continue in the 2021 admission season. We are now, as of this morning, 15% of the way through the admission cycle, and the number of applicants is up 37%. The breakdown by score bands shows a slight decline in the higher green and orange bands and a slight increase in the lowest blue band in 2012 through 2017. In the past 2 years, there has been a 3.9 percentage point decline in the blue 120 to 149 band, with most of the increase occurring in the green 160 to 180 band. This trend may be continuing in 2021. The green 160 to 180 band is up 52%. The orange 150 to 159 band is up 23%. And the blue 120 to 149 band is up 19%. This slide shows the total Black applicants for the past 8 years. Black applicants declined in 2013 and 14, but have stayed relatively flat over the past 6 years. This trend may be changing in 2021. Black applicants so far are up 39% this cycle. Here's the breakdown by score band for Black applicants. It stayed relatively flat from 2012 to 2017, with 5 to 6% green, 21 to 22% orange, and 73 to 74% blue. But in the past 2 years, there's been a dramatic improvement in Black applicant LSAT scores. A 5.6 percentage point decrease in the blue 120 to 149 band, a 3.2 percentage point increase in the orange 150 to 159 band, that's a 16% increase. And finally, a 2.3 percentage point increase in the green 160 to 180 band. That is a whopping 47% increase. I'm not sure what the cause is of this dramatic improvement, but one contributing factor is likely the new free official LSAT prep course through the Khan Academy that started in 2018. Use of that prep course has been rising dramatically. Almost half, 47% of LSAT test takers recently have used the Khan Academy. There's even greater use by Black applicants, 59%. In addition, Black applicants, along with Hispanics and women, show the greatest score improvement when they take 9 to 10 practice exams versus 1 to 2 practice exams. Next, I want to talk about the implications of this data on a law school's diversity of its student body, as well as its US News ranking. I want to use as my example a hypothetical law school in Southern California, just a hypothetical. California is one of 6 states that is now majority minority. California is 37% white. So our hypothetical law school is aggressively trying to increase its student diversity. The law school is also trying to continue rising in the US News rankings, which weights 1L median, LSATs, and undergraduate GPAs 22.5% in the rankings. Because US News does not give any weight to student body diversity, our hypothetical law school is forced to make some hard decisions. Our hypothetical law school has target medians of a 164 LSAT and 3.74 GPA for the fall 21 class. So what does it do with these 3 applicants? Applicant 1 from MIT has a 163, 373. Applicant 2 has a 157, 3.74. And applicant 3 has a 164, 2.97. Our hypothetical law school uses an index formula that weights the LSAT 60% and GPA 40%. So applicant 1 has an index score of 224, and applicants 2 and 3 have index scores of 218. US News encourages our hypothetical law school to admit applicants 2 and 3 because they each help on one of the target medians, even though applicant 1 has a much higher index score. Some say that because US News only focuses on medians, there is opportunity to add diversity once the medians are set. There are at least 2 challenges with this. First, only 20% of the students meet both the LSAT and the GPA targets. 65% at the law school meet either. And so that leaves only 15% of spots for applicants with less than a 164 and 3.74. Second, while 25% of the applications come in after the deadline of February 1st, 45% of Black applicants apply after that priority deadline when there are fewer spaces available. So to end, the final slide shows possible reforms that various people have suggested through the years. Frankly, none of them do much to address the two underlying problems. First, there is a lack of sufficient numbers of Black law school applicants and applicants with high LSAT scores. Second, US News is focused on the credentials of students with no consideration given to the diversity of students. I look forward to hearing the other panelists talk about how we solve these problems. On other things, we're going to hear about the role of pipeline programs and other approaches to increase the number and credentials of Black law school applicants. Second, whether US News would consider adding a diversity component to its rankings. Third, whether the ABA should allow law schools to go test optional to remove that barrier to entry. And fourth, whether states should permit graduates to practice law without a bar exam to take away that barrier to practice. Thank you.
Thank you so much, Dean Caron, for the conversation. I'd like next to introduce my fellow Texas Dean, Robert B. Ahdieh, who's appointed Dean and the Anthony G. Buzbee Endowed Dean's Chair at Texas A&M School of Law in July 2018. He's a graduate of Princeton School of Public and International Affairs and Yale Law School. He served as a law clerk to Judge James R. Browning of the U.S. Court of Appeals for the Ninth Circuit before his selection in the Honors Program in the Civil Division of the U.S. Department of Justice. While in law school, he published what remains to be one of the seminal works on constitutional transformation of post-Soviet Russia, called Russia's Constitutional Revolution, Legal Consciousness, and the Transition to Democracy. He's also published a lot of other leading law reviews. And prior to coming to Texas A&M, Dean Ahdieh was the K.H. Gurr Professor of Law at Emory University in Atlanta, Georgia. And during his tenure at Emory, he served as Associate Dean of Faculty and as Vice Dean. Let's welcome Dean Robert B. Ahdieh.
Thank you, Len, for that kind and overly generous introduction, as well as for organizing this conference along with Dean Collins. It engages what I think of as, and sometimes describe as, the most challenging issue that I believe is facing our nation. When we think about all the other challenges we're facing, social, economic, political, otherwise, I really believe in many ways, unless we can resolve this one, unless we can engage this issue of race in America, and particularly the experience of African Americans, of Black Americans, there's no other issue that we will be able to resolve effectively. My few minutes I want to spend walking through a few things that I think, as we think about admissions in the law school context, are potentially opportunities for increasing diversity generally, and particularly increasing African American, Black diversity in our law schools. But before I get to that, I want to just sort of note one sort of remark or sort of point that in many ways speaks to the earlier remarks that we heard over the course of the day, and even some of what Len opened with and Paul opened with. And it starts with a number. I was probably a decade ago now, was looking at some data from LSAT and saw the number of African American males, Black males, in the range of LSAT scores that at that time I was at Emory University that we were looking at. And the number, again, and I don't have it right in front of me, but I believe it was in the mid hundreds, and not hundreds range, about 150 African American men, Black men, who were in the range of Emory. And Emory was, a good law school, but not even the very top law school, in the very, very top category of law schools. And what that conveyed to me was not, what can we do? It's a hopeless cause. But instead, quite to the contrary, the fact that when we think about what we can do about this issue, what we can do to engage this issue, if we are starting with what we do at the stage of law school admissions, and frankly, although I'll say more about pipeline programs, frankly, even pipeline programs, we are far too late. We have already missed our opportunity. Fundamentally, when you look at numbers like that, it highlights for us the need to rethink in fundamental ways how our social order, how our economic order, how our political order works, and fundamentally whether we are part of a just, equitable, and non-racist system. As law students, as law professors, as law deans, I can say for those on the call, as lawyers, as judges, I think our capacity to engage this issue at that fundamental level is perhaps greater than any other population of professionals in the world. And so while I'm excited to talk about admissions and what we can do in terms of admissions, it's good not to lose sight of the fact that we are trying to engage a fundamental structural issue that we as lawyers and future lawyers have a duty to try and address at a more basic level as well. So with that, let me turn to sort of what happens in the admission sort of life cycle as I describe it. I'll say a few words first about pipelines. Paul mentioned them, Len mentioned them, and of course we had a fantastic session earlier. For those who weren't there for that, I would encourage you, just as a matter of hopefulness, to watch the video of it. I was inspired by the breadth of programs at University of Houston Law School, the Baltimore, the other programs are doing in terms of creating this pipeline, starting at an early stage and ensuring that we are creating that population flow into our programs. My only modest contribution on pipelines then to add would be the centrality in my experience, both at Emory before and here at Texas A&M, of relationships and of relationships that are both deep and broad in creating true pipeline. Not, I went and I found a kid and he got a good LSAT, so I was able to admit him, but really changing again the cultural dynamic at the target institution and the target community, and therefore at the institution, at the law school as well. And so in my experience, those programs work best when they involve faculty extensively, they involve staff, they involve students, they involve an ongoing relationship, they involve not just showing up, but substantive programs. One of the things we put in place when I was at Emory was faculty and students at the law school became faculty advisors to faculty and student advisors to the law journal at an undergraduate institution, right, an HBCU. And help those students really do the work and in that way get to know them and support them and encourage them down that path. When that happens, when the pipeline programs are premised on those kinds of deep and broad relationships, what I think happens is it's transformative. You grow the number of pre-law students, you grow the number of law school applicants, and ultimately you can even in the perfect world create kind of a feeder system where students at that school think of your law school, whatever other law school, as kind of where they go. If you're going to go to law school, this is the place you go to. So that's a little bit about my vantage on pipeline. So what about 1L admissions? And some of this again has already come up and we'll talk about it more, I think, as we go along. But three things that I would note in the context of the front end admissions. First is this idea of splitters, as they're sometimes called. So the idea is that if we look at the median for the LSAT at a given law school in their 1L class and look at the median for undergraduate GPA, there are students who are potentially at or above both of those. There are students who are below both, and then there are splitters who either are above one and below the other or vice versa. So in my experience, an admission strategy that at least is attuned to that can be incredibly effective. And I mean that in a number of ways. Let me start with the most obvious way. In my experience, those students are quite successful. We did not see at Emory and here at A&M, we don't see significant differentials in grade performance and outcomes of the students who are split this way versus this way. So including and even compared to the non-splitters, the two above. So in that sense, it's a good strategy for recruiting good students, but particularly I would say in a number of ways, it can be helpful to us in recruiting Black students. Why? First of all, I think it creates a greater dynamic or greater potential for success. Why? Because the African American students who are coming in, not to a person, but like most of their classmates, have either have demonstrated significant success in their undergraduate performance or have demonstrated significant success on the LSAT. That does, at least in my experience, and it's one data point, it does create a certain cultural dynamic and difference that I think can be very valuable. It's also helpful in terms of some of the financial things that we've touched on. In general, it's the case at most schools that students who are at above both or above both or above one that are more likely to receive scholarship support. And so a strategy that is premised on that means that you do not have this, you have less of a population of haves and have-nots than you would otherwise have, or many schools have, with the have-nots oftentimes not representative of the overall thing, being overrepresented in that group by minority students. Finally, that helps us, that can help a law school create a critical mass effect. I'm going to come back to that, but I do think maybe particularly for Black students, but for minority underrepresented students generally, that can be quite important. So what about then other measures beyond the LSAT? And again, we'll talk more about this, I think, over the course of the panel, but already there has been mention of use of the GRE. A number of law schools, including Texas A&M and others, they use the GRE as another path. Given the number of students who take the GRE, it becomes a path to increasing the potential pool of diverse students. There are various other things under the ABA rules, including where there's a program, where you have programs where you're admitting students from your own undergraduate university. The LSAT is not required, and so as a result, that gives somewhat more flexibility. Joint degree students are likewise subject to kind of a safe harbor. All those things are good, but they must be done systematically. It's not, if it's just random, they may or may not increase diversity, but if they're done systematically or used systematically, they can help in that way. And as we get, again, more further out that spectrum, there are increasingly experiments being put out there. University of Arizona is doing probably more of this than most, but experiments in thinking about yet other ways to identify strong candidates and students who will perform well. The last thing I want to mention in terms of 1L admissions is the role of affinity groups. So this was particularly at Emory, and we're doing some of this at Texas A&M as well, was we basically deputized the affinity groups, BALSA, LALSA, et cetera, Hispanic Law Student Association, to be part of our admissions effort, to be part of the engagement and recruitment of students. And what they were able to accomplish was to convey to students that in coming to this school, they will not spend every day having to be a trailblazer, right? Because the reality is, it's a problem if we put it on our diverse students, we put it on our Black students, that you have to break new ground, you have to clear the brush, you have to make a new path, because then they're not law students anymore, right? They're not able to do what it is that they came there to do, which was learn, get good grades, succeed professionally. So the use of these affinity groups, I think, can often be very helpful in terms of undergrad, in terms of 1L admissions. Very briefly, with just a moment or two I have left, I want to note transfer admissions is another thing. So after 1L year, some number of students will move to another school, usually based on their first year performance. This can be complicated, so I don't want to overstate it as a strategy, but I will say, again, used systematically, transfer admissions can be an important tool by which a law school can look systematically and say, there are students who have shown themselves to be able to excel in law school based on their first year performance, and that can be a way in which they enhance their diversity, they either advance their diversity goals. And so I do think that's important to think. But that only works. The transfer strategy only works, it seems to me, if one is systematic about making those students part of the community. If it's just show up and thanks for the money and have a good time and you helped us with our diversity, it doesn't work. It must be the case that a school commits itself to engaging in a serious way, in a systematic way with those students to ensure that they succeed. Last piece I'll mention is retention. So what happens after the students have arrived? The community, three things here. I think community is important. Affinity groups can be part of that. But the dean, everyone from the dean to the faculty to every member of the community have to own the issue of how do we make diverse students, Black students, feel at home in the community. So you've got to be able to do that to achieve retention. On bar success, one sort of silver lining of the COVID crisis, of the pandemic, it has highlighted for all of us the challenges associated with the bar exam process as it exists today. Resources, isolation, all of these kinds of things, support, family obligations. It turns out all of those things that so many of us faced amidst the pandemic, minority students have been facing forever, right? So they are new to me, but they were not new to so many of these students, right? So hopefully we can, on the back end of this, be more attentive to that. And finally, in terms of employment, using employment, including graduates of color, but also the community more generally, to identify this as a challenging issue. Now, there's lots of other possibilities as well. I think we'll talk more about them over the course of the thing, including Bob. I think we'll talk about this small group of us that have talked to him about the use of socioeconomic considerations in the rankings, and I think that's a fantastic goal. Yeah, but broadly, let me come back to where I started. All of these things are things that we must be and should be doing. But fundamentally, as law students, law professors, lawyers, judges, we should be asking ourselves the questions: how do we fundamentally restructure our social order so we don't have to have this panel in 5 years and 20 years? Thank you.
Thank you, Dean Ahdieh. I'd like to now introduce Professor Victor Quintanilla. He's an Indiana University bicentennial professor, professor of law, and affiliated professor of Indiana University Department of Psychological and Brain Sciences. Professor Quintanilla's research investigates civil justice design and access to justice by drawing on theory and methods within the field of psychological science, including experiments conducted with judges, lawyers, law students, and members of the public. He's currently serving as a principal investigator of a research line on mindsets in legal education, seeking to create, implement, and evaluate social psychological interventions to promote productive mindsets, diversity, and enhance the students' experience and performance throughout the pipeline of legal education. And he's received funding from it from Access Lex. He served as a fellow at the Center for Advanced Studies in Behavioral Science at Stanford University from 2015 to 2016. Let's welcome Professor Quintanilla.
Thank you, Dean Baynes. It's really a pleasure to be here. I'm going to load my PowerPoint. Let's see. Can you see my PowerPoint? Excellent.
Yes,
okay, great. Dean Baynes, thank you greatly for the opportunity to present on this panel here today at this important gathering on Black Lawyers Matter with this august fellow panelists. Today, I'll be discussing another point in the gatekeeping stage into the legal profession and a recent research project that I've finished with a fellow team of researchers, which is entitled the California Bar Exam, Minimum Competency, Public Protection, Disparate Impact, and National Standards, which is available on SSRN, and the chat just went, that makes that available. I want to first begin by recognizing that in doing this research project, I'm really standing on the shoulders of many who've come before me, who've written and spoken about these challenges across time. And I see our role as a research team to offer vital, critical, empirical evidence on these questions. My aspiration is that this research will be useful to policymakers who are weighing now what kind of decisions need to be done to improve diversity, equity, and inclusion within the legal profession. Over the past several years, I've had the great fortune of working with an amazing team of researchers on a project called MILE, Mindsets in Legal Education, and we're from many different disciplines: law, psychology, education, sociology, statistics, and from many different institutions as well. Several of us teamed together to work on this particular project. So having said that, let's begin with the pressing challenge, the lack of diversity in California's legal profession. So as of 2019, there are over 190,000 licensed attorneys in California. And yet while white attorneys account for 68% of California's active licensed attorneys, people of color constitute 60% of California's population. And what we know is Latino and Black attorneys are particularly underrepresented among California's attorneys in comparison to the statewide population. While 36% of the statewide population is Hispanic, Latinx lawyers constitute only 7% of the legal profession. And while 6% of the state is Black, Black lawyers constitute only 4% of the legal profession. This is a pressing problem for many reasons. Having a diverse legal profession positively impacts the administration of justice, ensures fairness, and promotes the law, rule of law. And these aspirations are central to the State Bar's mission of public protection. This is especially the case in our multicultural and interconnected world. This lack of diversity and inclusion within the legal profession, though, are not inherent, fixed, or natural. Rather, this lack of diversity is socially produced and constructed by policy choices and institutions affecting the pipeline within the legal profession. Gatekeeping decisions by institutions produce, reinforce, and reproduce underrepresentation. The pipeline into the legal profession involves key gatekeeping decisions: the LSAT, admissions into law school, matriculation through law school, and licensure, the bar exam. Today, I'll focus on one part of this, the selection of the pass threshold on the bar exam, the cut score. I'll discuss how the choice about this gatekeeping institution produces disparities and reinforces inequality, and specifically how this lack of diversity in the legal profession can be enlarged or attenuated by changing decisions about the cut score. The underrepresentation in the legal profession that we see today is socially produced by a set of institutional and historical decisions at multiple stages, including policy decisions about the cut score for the bar exam. The big key here is that the choice of the cut score is also a choice about the legal profession's racial and ethnic makeup. Indeed, there are many possible and open available cut scores to choose from. 1350 is the most common, the median and mode cut score used across jurisdictions. 1330 is New York's current cut score, another large, ethnically diverse, economically vibrant state. And 1300 is the lowest cut score used by several states as well. Prior to August of 2020, the prior cut score was 1440, and it was the second highest in the country. It was established by the State Bar in 1987, apparently without any standard setting or validity study. While our own research was underway, the California Supreme Court lowered the cut score from 1440 to 1390. And in so doing, the court stated that it would consider any further changes pending the recommendations offered by the Blue Ribbon Commission on the future of the California bar exam. But what we'll see is that 1390, we'll see that the cut score will only have a modest impact over the period studied and will continue to produce significant racial and ethnic disparities compared to the national median of 1350 or New York's cut score 1330 and similarly at 1330. So today I'll lead us through the studies that we conducted. First, we'll talk about the racial disparities at 1440. Then I'll speak about briefly 2 simulations that we conducted using actual score data, showing how cut score changes affect the diversity and inclusion within the legal profession. And then last, I'll discuss a project that we did, which shows the lack of any relationship between cut scores and attorney discipline. So let's turn first to racial disparities at 1440. What we know is that going from 2009 to 2018, the proportion of applicants passing the bar exam has decreased over time. The percentage of failing has increased for all groups. That said, what this shows is that 1440, over the past 11 years, there have been consistent disparities in passing rates among examinees on the basis of racial and ethnic backgrounds, where minorities have consistently passed at significantly lower percentages than white applicants. Now, one of the most engaging aspects about this particular project is rather than examining the data on 143,000 bar exams taken in the stylized this way, we restructured the data to actually focus on the 85,000 unique examinees in our data set. So this data set included each applicant's complete exam history, including their performance data for all attempts of the California bar exam across these 11 years, which allowed us to focus on unique examinees. And that meant we counted each examinee only once, even if they took the exam several times. Many would agree that this would be the preferable way to do this kind of analysis, but few have had the opportunity to analyze the data this way. What this does, it allows us to categorize whether people have actually would be bar passers, either first time or eventual passers, or never passers if they had never passed the bar exam during this time period. So let's examine, get a sense first of the demographics within the sample. What's the racial and ethnic composition? So we had 85,000 unique examinees over the 11 years, and what we saw is about 48,000 of them were white, 57.1%. About 4,000 of them were Black, 5.2%, 18,000 of them were Asian, 21.6%, 9,000 were Hispanic, 10.7%, 1,000 were identified as other. Examining the data this way, so what's the percentage of applicants who pass the bar exam, whether on their first or eventually at the 1440 cut score? What we saw is that 75.8% eventually passed, 24.2%, however, were never passers. But how does this differ between racial and ethnic groups at 1440? What we see is large disparities between white and Black applicants, for example, and substantial gaps. What we see is that 80.5% of white applicants who sat for the bar exam across these 11 years eventually passed, whereas only 53.1% of these applicants, Black applicants, eventually passed the bar exam. So what this means is that for every 1,000 white test takers who sat for the bar exam during this window of time, 805 of them would ultimately have passed the bar and joined the legal profession, whereas only 531 for every 1,000 Black applicants would have done so. Now, we restructured the data, which allowed us to examine how changing the cut score would have impacted the disparities in the bar passage across these 11 years. And this, in effect, centered on the highest score of the applicant. So let's say we had an applicant who took the bar exam 3 times, and reached a 1330, a 1350, or 1390. Had the cut score been 1390, adopted 10 years ago, this applicant would have been a bar passer. So this is the kind of analysis that we did in this instance. And what we see, again, at 1440, 80.5% of white applicants passed the bar exam, only 53.1% of Black applicants passed. But if 1350 had been adopted as the cut score 10 years ago, this changes. 89.5% of white applicants would pass, and 70.1% of Black applicants would pass the bar exam. What we can see is that depending on where the cut score is, the Black-white achievement gap and disparities really do close greatly. So choosing the cut score matters a great deal about narrowing and closing disparities. Another way of looking at this is that for every racial group, we saw performance increase depending on where the cut score is. But we particularly saw increases for minority applicants. And this is especially so in the move from 1390 to 1350 for Black applicants, as you saw. And you can also see that as we move towards 1300, these gaps really do close greatly. So what does this mean in terms of the diversity and inclusion within the legal profession? How does the choice of cut score affect the legal profession? So to do this analysis, what we see is that cut score has a powerful impact on the numbers of newly admitted racial and ethnic minorities in the legal profession. While all groups receive a benefit with these different cut score changes, if 1390 had been adopted as the cut score in 2009, the number of newly licensed Black lawyers would have increased by 12.5%, 294 more Black lawyers in California. If 1350 had been adopted as the cut score in 2009, the number of additional Black lawyers would increase by 32.1%, 753 more Black lawyers in California. Finally, if 1300 had been adopted as the cut score in 2009, the number of additional Black lawyers would have increased by 49.2%, meaning there would be an additional 1,154 more Black lawyers in California. What happens when this inflow is added to the existing pool of lawyers in California and the legal profession? What we see is at 1390, this additional 294 Black lawyers would have meant that there would be a 3.9% increase in the composition of Black lawyers in California. Had 1350 been adopted with the additional 753 lawyers, the available Black lawyers in California would have increased by 9.9%. And had 1300 been adopted, again, with the increase of additional 1,154 Black lawyers, there would have been a 15.4% increase among Black lawyers in California. The key here is that decisions about the cut score powerfully shape diversity and inclusion in the legal profession. Now, finally, some say that lowering the cut score would allow in the wrong kind of people, less professional, less ethical, into the legal profession. So we tested that. We gathered the ABA's disciplinary data, and we actually looked at complaints filed in jurisdictions against attorneys, charges filed against them, and disciplinary actions over the most recent 6 years across 48 US jurisdictions. And we evaluated whether there is any relationship between choice of cut score and discipline. what we found is that there's no significant relationship between the choice of cut score and public complaints. In fact, actually, as the cut score goes up, complaints go up, but that wasn't significant. We also saw no significant relationship between the choice of cut score and charges filed against lawyers, and no significant relationship between the choice of cut score and attorney discipline. So we've set aside this, this accusation that we're letting in the wrong kind of people. Now, in conclusion, I've spoken about the underrepresentation and lack of diversity and inclusion within the legal profession. I've pointed out that this is based on institutional choices. This is socially produced by gatekeeping decisions within institutions that can produce, reinforce, or reproduce this underrepresentation. I focus on a particular institution and a particular choice of gatekeeping, the selection of a cut score, and show that there's many different available, open and available cut scores that are possible. And also how decisions here can either amplify the underrepresentation or enhance diversity and inclusion. Ultimately, the choice of cut score is a choice about the racial and ethnic composition of the legal profession. Thank you.
Thank you, Professor Quintanilla. I'd like now to introduce our next panelist, which is Robert Morse. And Bob Morse is the Chief Data Strategist for US News. He takes a lead role in survey design, ranking methodology, and higher education research, as well as monitoring data collection for all the company's academic rankings, including best colleges, best graduate schools, best high schools, as well as best global universities and best online programs. Morse developed almost all of the recent methodologies that are used in the best college and best graduate school rankings, and has worked full-time on both the best college and best graduate school editions since 1989. He's the author of the US News blog called Morse Code, Inside the College Rankings. He's also one of the founding members and on the board of the International Ranking Experts Group, as a frequent speaker at higher education conferences in the US and around the world. Let's welcome Bob Morse.
Well, thank you very much. And it's definitely an honor to be part of this conference, and the speakers have been amazing, and the passion that people have around this topic is, you can feel it through, I can feel it through my Zoom screen, if I can put it that way. So it's real. Can my presentation be put up? Can you go to the next slide, please? So, I mean, US News, the topic of the conference is diversity and social mobility, and what US News is doing and what US News could do, and what are some of the issues and roadblocks that we've had, or choices that we made. So US News does have a diversity index currently, and we've been publishing it for many years for law schools, and it has its strengths and weaknesses, but it does, the index itself shows the likelihood of any particular classmate at a law school running into somebody from a different ethnic group. So it's not a measure of the goal. That's what it measured, and it does include the full and part-time law students. It doesn't count international students, because, using what Paul was saying, they're not actually identified as being an ethnic group, at least according to OMB. They're just called international students. And we produce an index from 0 to 1. And if a school gets 1, that means every other student they run into or in their classroom is going to be from a different ethnic group. It was based on something in a public opinion journal that US News sort of took the idea and modified it for law schools. The next slide. So it does provide value in the sense for those who look at it. It is based on ethnic data alone, aggregated ethnicity data, not an individual ethnicity like African Americans or Hispanics, but a high index value does show that a school is more diverse in this aggregated concept of diversity, and a low index value does show that particular school is less diverse. And the index does, if one ethnic group is a very small percent of the, a very large percent of the enrollment, a school gets a low index value. And I think a school like Howard, I think, which was talking earlier, where 80 or 90% of the students were African Americans, would get a low index value, even though they're meeting an important societal need. So the US News Current Diversity Index certainly doesn't measure how successful schools are at meeting any state, local, or national diversity goals. It doesn't measure these particular goals that we've been talking about at the conference today, the lack of and the impact of low enrollment of Black JD students and all aspects of the legal profession, and it doesn't take into account ethnic diversity, which is another type of diversity. The next slide, please. So these are the schools that are doing the best using the fall 2019 data. So the schools that are in the 70s means that there's 70% chance that you run into a different person, a different ethnicity. The list does have two historically Black colleges on it. I think, I guess Florida A&M and UDC. UDC has been designated an historically Black by the federal government, so they don't have 100% of their students who are African Americans, but does show that there is Hawaii and some private schools and public schools. But next slide, please. These are the top performing schools. So as I mentioned earlier by Paul and maybe others, US News has added social mobility to our best colleges rankings. Next slide, please. And it was a byproduct of a lot of research and experimentation. We started working on it way more than 3 years ago. In this particular indicator, which we developed for best colleges, but it does show the US News, I don't want to say willingness, but if there's data there, we'll implement and we'll put into effect things that are important. The federal government began mandating schools to report income-based graduation rates. These are using the Pell Grant students, which is a federal entitlement, as the basis for compiling the federally mandated graduation rates. So next slide, please. Why did US News add social mobility? We wanted to directly assess how well schools are supporting their students. This is both academic, financially, and socially, from low-income households. And this can be a proxy for academic quality. And so the Pell Grant graduation rate, which I'll explain more, the vast percent of the students come from families who have under $50,000 in income, or the neediest group of students in society. Next slide, please. We also added it because it diversified our other measures that incorporated graduation and retention rates. So this is an outcome measure, how well students are doing. It is sort of one measure of social mobility that schools are accepting Pell Grant students and they graduate them. It's also I'm sure some of the schools that are deans are on this panel, their parent institution or the law schools themselves have as a mission, that is a core part of their mission, to bring students that are the less well off or from different circumstances into their student body and graduate them and give them the tools to succeed professionally. So this is the same, doing that in the undergraduate level. The next slide, please. I'm going to quickly go over the indicators that we used, even though this is a little wonky, but we do use we use two separate ranking indicators assessing 6-year Pell Grant graduation rates, and they're both weighted 5%. So the next slide, please. Next slide, please. Uh-oh. Okay. I mean, it's important that, so one of the indicators is the Pell Grant students' 6-year graduation rate. So these are just the proportion of any given first-year class that had received Pell Grants, and how they, and the proportion of them graduated 6 years later. And we discounted, in essence, by the proportion of the fall, and we multiplied by the proportion of the fall entering class that was awarded Pell. So the reason why we're doing that, and I'm not saying this can apply to law schools, but the premise is that there are the elite institutions in the United States, Harvard, Yale, or Princeton, and many others, I'm not picking on them, they do enroll a smaller percentage of Pell students, and they do graduate them at extremely high rates. And those students do have social mobility, but the institutions themselves we felt they shouldn't score at the top of our social mobility ratings, because in order to succeed as an institution in social mobility, you need to have sort of a meaningful proportion of Pell Grant students and do an above average job of graduating them. The next slide, please. So the other indicator that we use is sort of over performance, underperformance, how the Pell Grant graduation rate related to the non-Pell Grant graduation rate. And we cap that at 1%, because after that you've received equality. So if your Pell Grant students are doing less well than your non-Pell students, you don't score as highly in this indicator. The next slide, please. So hopefully you can see this, but these are the winners. These are the top 30-ish universities. This is from the latest rankings that were published around 6 weeks ago. And you can see the University of California schools do really well in this, and there's others. Now, the University of California system does enroll a large proportion of students with Pell Grants, and they do graduate their students at a really high rate, relatively speaking. And there's other in New Jersey, and so these are schools that are doing really well in this social mobility indicator that US News has developed. Okay, next slide, please. Could US News come up with a factor like this? Well, we are working on it. Next slide, please. Right now there isn't any data yet, but as we alluded to earlier, we did meet with LSAC, and on LSAC's initiative, there's a possibility of some data sharing, and LSAC has the number proportion from their application process of the students who received Pell Grants when they were undergraduates, and also the proportion of fee waivers. So both of those could be indicators of that come from low income students or low income households. And those could be indicators of economic diversity if we develop some kind of data sharing initiative, which we're hopefully will happen. And it could be used analytically. So the next slide, or at least produce a listing. We're also looking into a more sophisticated measure of diversity that could take into account percent of schools underrepresented minorities. That would exclude Asian Americans, and measure that against some kind of a benchmark of either the state or the college age population, or the lawyer population in their state or nationally, and depending how the school scored, whether you were over or underperforming your state benchmark, your national benchmark. So this would be relative to some population benchmark in that state. So these are some things that we're experimenting with. And I think that's about my time.
Thank you so much, Bob. Our next panelist is Kellye Testy. Kellye, or former Dean Testy, President Testy, I should say, is the President and Chief Executive Officer of the Law School Admissions Council. Under her leadership, LSAT has worked with its partners in the legal education community to promote universal access to justice and to build a more just and prosperous world. President Testy came to the Law School Admissions Council from the University of Washington School of Law, where her 8-year term as dean, during her 8-year term as dean, she was the first woman to hold that position. She's also served as professor and dean at Seattle University School of Law. And while dean at both University of Washington and Seattle University, Testy founded numerous programs, was named the nation's second most influential leader in legal education by national jurists, and served as president and in other roles of the Association of American Law Schools. President Testy is a first-generation college graduate who earned both her undergraduate degree in journalism and her law degree from Indiana University in Bloomington, her hometown. She graduated summa cum laude from Indiana University Maurer School of Law, Bloomington, where she was editor-in-chief of the Indiana Law Journal. After graduating, she clerked for Judge Jesse E. Etchbach, the U.S. Court of Appeals for the Seventh Circuit. Let's welcome President Testy.
Thank you so much, Dean Baynes. I really appreciate that kind introduction, and I want to begin with a big thank you to you and Dean Collins for convening this conference, and to everyone who's made it possible. It is such an important conversation, and I want to, like David Wilkins did in the keynote, remind us that this conference on Black Lawyers Matter comes within the context of Black Lives Matter and a call for renewed focus on racial justice that we all continue to need to put even more focus upon. And I want to start there because it's in that context that we all begin our work. And when we understand the pernicious effects of racism in our world, it is sadly unsurprising that the effects of that infect every stage of the educational process. And so we see deep structural inequity in education all along the educational pipeline. And then law school that takes for its students, college graduates, that pool, we're already looking at a narrowed pool by the time we get to the admission of law students. So it's within that context that the Law School Admission Council has always asked, how can we be part of evening that playing field? How can we help make sure that law school admission is full of fairness and integrity and equity? And our founding was exactly to do that, because before the LSAC and the LSAT were launched, law school admissions were largely handed to white male applicants because they were done on the basis of where did you go to school and who do you know, and other forms of bias were very common in that process. And it was a desire to have that playing field be more even and let applicants, no matter where they went to college, show their potential for success in law school that gave rise to our organization. So you can imagine how hard it is and how upsetting it is when we start to hear the criticism of, is your test, is the LSAT a barrier rather than a help in this process? And so I want to address that head on today because we have sleeves rolled up and we are ready to engage on that question and to look at that fully. And I want to start by saying today that if making law and the world more equitable on racial lines were as simple as saying, then let's not use the LSAT. LSAC would have been at the forefront of that because that's our mission, to always hold equity first and foremost. But I want to start today by saying that while I wish it may be that simple, it is not. And let me explain a little bit of that and some things that I think can make things better. So let me begin with noting that all research supports that when you use a test designed for the field, like the LSAT is for law, as one factor in a holistic admission process, all research supports that is the most equitable way to do admission. And so if your goal is equity, it's clear that that's the best way to do it. Where things get difficult for us here in the United States and the way that we're seeing law school admissions work is that our advice about how the LSAT should be used runs up against barriers itself. And it's often not used in the way that it was designed, nor intended, nor according to that advice. And I want to say there that we need to ask why. What is the pressure that makes that happen? And of course, Bob Morse, who's on our panel here, is commonly the person and the institution that people turn to and say, it's the pressure of US news rankings that causes us to overuse the LSAT and to manage for that. And I want to say there that then often means that we look at law school deans and say, deans, just resist that, just don't do it. And I, having been a dean myself for almost 15 years, having sat in that seat, I want to make sure we all understand that we need to all take responsibility for this, because a dean may say, I'm going to resist that pressure, but students care about that, alumni care about that, universities care about the ranking, and it's that collective pressure that's pushing there. So I do want to say that one of the things that I hope we can all do is talk about how do we move forward with using the LSAT in the way that will enhance equity, as we know it was intended and can do. I also want to note today that one of the things that gets commonly said is let's have more flexibility for law schools. For instance, use some other tests, or maybe not use any test, maybe have multiple pathways by which you could be admitted to law school. And I want us to note that one of the downsides of flexibility is a lack of transparency. And we all know that when the rules of the game aren't clear, when there's a lack of transparency, who's often hurt most by that? Black, brown applicants and other minoritized applicants to law school. And that's one of the things that we have to all make sure we're also thinking well about as we move forward, that our natural instinct for, oh, flexibility is going to help, may not in fact be the case. And that's why, for instance, that there is no credible research that shows that test optional policies enhance diversity. And so we have to be cautious in examining that myth as we move forward. One of the issues that I want to also mention today for our consideration is that it's often said, and one of the panelists earlier today said it, that the LSAT is biased. And one of the issues there that I think is important for us to parse through is that measuring difference is not the same thing as being biased. And one of the issues that we have to understand is that if you have, as I noted at the outset, deep structural inequity along the educational pipeline, anything that measures academic preparedness, whether it's a test or a GPA or anything else, is going to reflect that. That doesn't mean that the instrument itself is biased. And I want to make sure we note that we are so deeply committed to that we have a 10-step process to make sure there's no differential for any subgroup with anything that we use on our test, and a long, long record of making sure that that's the case. Now, I want to turn my remarks. I hope I've clarified a few things that sometimes become stumbling blocks in all of us making progress together in this realm that's so critical. And I want to note a few things that I think can, in fact, help us as we all move forward. And first, I hope it's that we do take collective responsibility for the holistic pipeline from pre-law to practice. Victor's work on bar cut scores, for example, is so critical to show what really matters at that stage. And likewise, Victor, I was thinking that, proper use of the LSAT so you don't have a cut score, so to speak, will also be, very instrumental as well there. That whole pipeline matters because we need to look at it holistically, all the way from pre-law to practice, and all take collective responsibility for making it better. We heard some wonderful examples today. I want to especially say Mr. James O'Neill, his remarks on that program were just phenomenal because it goes to the heart of building up academic preparedness and building up the opportunity, giving students the window that, yes, you can be a lawyer. I know as a first generation college grad myself, that was so vital for me to even envision that law might be a possibility. And then giving that holistic support because it's not just about academics, it's about so much more. And then I also want to note too that we should all make sure that we're doing everything we can holistically between law schools, the bench and the bar to think about even making sure that the regulations that we do have already are being applied in the right ways. And then if we need tweaks to that, to making those. So for example, under the ABA standards currently, law schools have the room to give the LSAT whatever weight they would like to give it. And they also have some exceptions that they have available in 5033 that I think should be used. The ABA standards themselves say that you must use a test according to the rules of the test publisher. And so that's something that we should all talk more about as well. Now, one of the things that I want to do in closing is to really issue us all a call to action. This conference should be annual, and we're certainly committed to being a sponsor of it annually, so that we are taking stock every year in measurable progress toward making the legal profession more equitable and more diverse. And I want to let everyone know today of our commitment to doing that. You also know that we're in the process of hiring our next Chief Diversity Officer, Kent Lawless, who many of you know, great leader in the African American community, served us for 30 amazing years. And as our new Chief Diversity Officer after Kent's retirement comes on board, we are going to convene a national roundtable about the future of law school admission so that we're using evidence to get to what will matter so that we don't go backwards. Just as the demographics of the world are changing, we want to make sure we're not changing the rules of the game and we actually give everyone that opportunity for access and to thrive. So I want to end by saying that we had a wonderful presentation today by our historically Black colleges and universities, our HBCUs, and I loved hearing from all those deans. Well, we may not all be able to be HBCUs because that history is unique and so special, but we can be CBCUs, currently Black colleges, universities, and law schools. And LSAC joins all of you. Just as I tell our candidates, you're so much more than your test score. We're so much more than any one assessment instrument. And we'll be there helping bring the pipeline of diverse candidates forward and helping them thrive on their enrollment journey to become lawyers and serve our world in the way we need to for it to be more just and more equitable. Thank you so much.
Thank you so much, Testy. We'll take you up on your offer to have this as an annual conference. This is a great idea to sort of take stock every year of what we're doing and how we're doing, and that's really important. And thank you all the panelists for such a scintillating conversation at looking at each aspect of the pipeline. I think the thing that I've learned all today is that each aspect is really, really important to make sure there's no leakage at any stage. And we all have a role to play with respect to that. So let me ask you a few questions in the times that we have left. And so, so let's go to the heart of the panel. is the use of socioeconomic factors in rankings or diversity in rankings. And Bob Morse talked a little bit about that US News is open to doing either and is sort of looking at both of those things. They've done a really great job of having diversity rankings at the moment, but they're very open to this. And so I'd be curious where the other panelists are on that question, because many in our communities have been saying, oh, if US News took this into account, diversity or now socioeconomic factors, that may be, as President Testy talked about, deans are under incredible pressure to increase LSATs. And I remember hearing a conversation from Ted Shaw years ago that he was struck when he went back to Columbia Law School that even that dean at that time was talking about increasing LSAT scores, right? And how it was so important. So every dean is under this incredible pressure. And so would this be a way to sort of ease that pressure by actually allowing deans to also factor in these other factors that may balance out the quest for high LSAT scores? Any thoughts? I open up to the whole panel. President Testy.
Lynn, I would say to begin that I think anything that reduces the impact of any one factor in the rankings will be helpful. And law rankings have a higher weighting for the entering credentials of candidates than do other rankings. So I think that's one of the pressure points that's very difficult. And I also think it's the right kind of a measure to look to, because anything that reflects more diversity will encourage that.
Great. Any other, how about the deans and Professor Quintanilla? Is that Dean Caron? I see your hand up. Yes.
Yeah. Yeah. I mean, it seems to me that because all law schools have diversity as a priority, it would be helpful to have US News factor that into the overall rankings. And I think it harkens back to, as folks know, there have been ongoing conversations with US News because almost all law schools put a high value on faculty scholarship. And so there've been conversations about, since it's a priority for law schools, it'd be nice if US News would measure that as well. So I think it'd be great to have US News to measure what almost all law schools, if not all law schools, are trying to do.
Dean Ahdieh, what do you think?
Fantastic. Again, I said I was glad to be part of the group that went to Bob to talk about the possibility. And I think to me, we have to figure out how to do it. It's a little more complicated at the graduate level, given the status of the applicants. But there must be some way, would be what I would say. And I think, look, it is partially Kellye's point about anything that dilutes the emphasis on any single factor, reduces the necessity and the value of gaming. But also, frankly, it's reflective of the reality of not just what we want to do, but really what it means to educate world-class lawyers today.
President Quintanilla.
So I think that the issue is that the current system as it operates really pulls us away from these aspirations of integration, diversity, and full inclusion. And as President Testy has pointed out, the US News and World Report creates powerful incentives within law schools. So the current rankings, they don't factor these into targets. And without the inclusion of these, it's certain that these disparities and distortions will continue going forward and probably worsen in light of COVID-19 and what's happened in society. We know Gloria Lansing-Billings has spoken about educational debt and spoken about the accumulated structural disadvantages that we experience within society. And applicants who contend with these structural disadvantages have further distance to travel. So this is critically important. And my sense is that with the inclusion of these metrics, it will likely change the way that we dole out scholarships. Need-based scholarships will likely be need-based scholarships. The one other thing I'd say is Angela Davis has recently spoken about moving, not just about diversity and inclusion, but about justice. And what about capturing a metric of the exiting class that goes into public interest work and the way of kind of capturing that within our US News and World Report rankings as well? Structural disadvantages, diversity, inclusion, and public interest as well.
So I agree. So Bob, you have 3 deans, 1 former dean and potentially an aspiring dean, Professor Quintanilla, all suggesting that US News do something. We're not sure exactly what, but The other thing I would suggest is, maybe there should be a metric for racial justice programs, or, so where you have all these other programs of intellectual property or health law or international law. Why isn't there a ranking for racial justice programs? A lot of schools actually have them. Yale just opened up a Yale Center for Race and Law. So why can't we do that as well? But let me point out something Professor Quintanilla talked about. In the present circumstance, as deans, unfortunately, a lot of the scholarship dollars go to students who have the highest LSAT scores. Has that your experience at your law schools? Is that the case? Do you have need-based scholarships or not? And do you think that U.S. News and World Report actually creates an incentive to give to students who have higher LSAT scores, which are more likely to be from higher socioeconomic backgrounds?
Can I make
Yes.
one comment?
Yeah, sure.
Obviously, I'm not a dean, a law school dean, so that goes without saying. But I did want to make one comment. This is actually somewhat along the lines of what Kellye said, that, and I won't call it a conundrum, but I'll call it a ranking reality. We have said that we've studied these issues. We're hoping that law school deans will, in some ways, I don't want to say lobby LSAC, but at least speak up, or whatever the process would be to, quote, free the data, if I can say it that way, to data share. I know there may be reluctance to do that because then US News can analyze the data, but the conundrum is that the US News is using the LSAT and the GRE. It's still predominant LSAT world because it's required by law schools and the ABA. It's a required gateway exam, and maybe our weights need to be adjusted. But the concept of using LSATs as a measure, as an indicator, is comes from the industry. So I'll make that one comment, that and US News does have to be open, and we do need to look at some of the things that I mentioned and come up with ways of measuring these things, which we've only partially done so far.
Great, we appreciate that, Bob. We appreciate your openness to that.
And Lynn, I would just add too that we're certainly glad to work on what's the right data to help with the deans, because one of the other things that some of our researchers have pointed out to me is a really good measure about were your parents college graduates or law school graduates, and that's a key factor, and that's something that is easy to know too. And so what as the deans have a conversation about this and with US News, we're certainly happy to help in any way we can. We see all of our interests aligned in helping make this all better.
Great, we appreciate that. So do you think that the current system, does it favor students getting scholarships who have higher LSAT scores, which in effect privileges students who are from higher socioeconomic backgrounds?
Yes.
Okay.
In case not everyone says them, yeah, of course it does. Again, but the only thing I would say is, again, I think we got to think about this in a matter as a systems theory matter. There's a hydraulic, so it's not that slay this and then the world is good. So we have to sort of think about it as the hydraulic effects of, if it's not one thing, it's another thing. So I would echo. I haven't heard it phrased exactly the way when Kellye says dilute or sort of make sure there's not an overweighting of any single thing. That's really where the solution lies. It lies in the fact that if there are multiple nodes by which law schools distinguish their excellence, and I'm going to distinguish it one way, and Paul's going to distinguish it, and you're going to distinguish it another way, we then get a result where students then have the choice of saying, look, this school is focused on strengths and priorities thing, as opposed to we're all chasing after one brass ring, right? Yeah, so that's the thing that I would say. So I do think there's a role for US News and a role for LSAC, but if we think about it as reducing the salience of any one variable, and I might even say any one test and any one ranking, that's really where, to me, the solution lies, because then we're not overly dependent on, we're all chasing the same single thing.
Okay. Dean Caron, you have your hand up?
Yeah, and to kind of say the obvious, right? When we give excess scholarship dollars to folks with high LSAT scores and less merit need, right? Then those are the students that predominantly predict to graduate higher up in the class and have sort of better job opportunities. And then the students without the higher LSAT scores graduate perhaps lower in the class and have a harder time getting a job. So the inequality kind of deepens as we go through the process.
Thank you. There's been a couple of questions in the chat. We have a few moments left, but it's important for me to ask some of the questions. So one of the questions earlier directed to Dean Caron was not, the person said he didn't understand the split scores and how that related to your example with the students who, the student who was, I guess, an MIT graduate had scores both above your medians, and then the student who had scores that were split. So we wanted to know if you could go into more detail.
Yeah, sure. The example was the MIT graduate was just below the medians for the law school, even though that graduate had a high index score. If we're just factoring in US News, then the students that are above on one and below on the other are more attractive from a rankings perspective.
Okay, that's helpful. And then there was another question for President Testy about Khan Academy and its effectiveness as opposed to a Kaplan program or some other commercial LSAT program.
Sure. Happy to take that. We are so excited about our partnership with the Khan Academy. It has had incredibly high usage, and I think, as one of the earlier speakers noted, particularly among African American, Latinx, and also women as a group. And the data now is starting to come through about the efficacy of that, and that is very encouraging. When candidates use that platform as recommended, and it's not a ton. I mean, it's just doing a certain pacing on it. It's a lot of improvement, and the highest improvement is in the same 3 categories that I just noted. I also want to note that we've ourselves launched a free preparation tool as well called Law Hub. And this is, I think, going to, Dean Caron noted how some scores were as a whole coming up. I think those are factors that are helping, because what we're talking about, bottom line here, is access to learning. And if you even out access to learning, you can help everyone, and they're acquiring skills that will help them in law school, the 3 critical skills that will help them most there. So we're pleased with that partnership, Dean Baynes, and we'll certainly keep accelerating our efforts to do more free preparation and working with all of our schools on the many programs they do in that realm too.
Great. So 2 last questions before we break. So another question from the chat, I guess it's directed to Dean Ahdieh about use of affinity groups, and I guess the concern was the burdening of the affinity groups. So I don't know if you want to respond. I think you were talking about using affinity groups in recruitment and retaining student.
Yeah, so great. So it's a huge issue. Yeah, and I think I mentioned it, that as we think about the community element of retention, it's important that while the affinity groups have a role, that all of us, dean, faculty, staff, and all students embrace that as part of their task, because again, it's not, I won't say it's not appropriate, to place it on the affinity group, say you own this. What I would say is that, again, I think in well-structured ways, it can be effective. So I'll give you a very concrete and narrow example. We had a Balsa banquet that we shifted the timing of it so that the timing of the banquet was at the same time as our visiting student weekend. And so then that became part of that program. So it was a relatively low, and then we also say we doubled down in terms of investment in the banquet, in terms of getting funding, so the students have to fundraise less. So I think for the experience of the Balsa students, it wasn't actually an added burden. It was just it became part of the program there. But I don't want to understate it. Insensitivity to that would be as problematic as any benefit you get, for the reason that I said about if we're doing this well, it should be the case that underrepresented minority students should be able to go through their education, not identically because of the nature of the world, but without the added burden of, and it's your job to help us keep up the good work.
Great. And one last question, Professor Quintanilla. I guess what I would say is that thank you, Dean Ahdieh. Some would say, I would imagine, is that if you move the cut score, they're unqualified. I'm not saying that's from me, but that's what some might say. And I'm sure that of our 600 or more members of the audience, somebody's probably thinking that. And so I just want to give you a chance to think about that and respond to that.
I think that it's important to take a historical lens on this, because these arguments have been with us for quite some time. And the creation of the bar exam has an exclusionary component to it. It was truly a means of exclusion. Elihu Root in 1916, when was speaking before the New York bar and spoke about concerns about immigrants and children of immigrants taking over the legal profession, because fully half the members of the New York bar were immigrants or children of immigrants. 100 years ago, this infrastructure was created. There's also this story of kind of the cat and mouse game that the South Carolina bar played every time a new member of the bar was a person of color, and kind of new structures that would put in place to make it more difficult for people of color to do this. So I think, and Ta-Nehisi Coates spoke about this recently and spoke about concerns by majority group members about the entrance of racial outsiders, and called it this concern about the Great Fire. And we see this with the creation of impediments and barriers and exclusion for entrance to the bar exam. In 1970, we saw that bar exams were challenged in court. Courts uniformly said that if Title VII had applied, this would clearly be illegal, but Title VII doesn't apply, so it's not illegal. That's normatively bankrupt, okay? And the system looks pretty similar 50 years later today. We have the same similar licensure system, not a convincing case made about why the cut scores are where they are, or why the system operates as it is. And we have these crises in society. We have underrepresentation within the legal profession, inadequate diversity, access to justice problems. And we have these disparities, pronounced disparities that the bar exam has created. And this concern about consequential or content validity, which is still hasn't been shown. And the California bar is working on that, but trying to, and talking about more skills components. So I think the issue is we've got to be skeptical about these claims given the history of this. And there's so many good people within bar associations that are trying to do the right thing to redesign the system to make it more egalitarian today. And especially in this moment, in light of COVID, in light of the concerns in society, we've seen these alternate systems that have created supervised practice, which is interesting, changing the content of bar exams in light of Carnegie McCrae, following New York's lead of a 1330 would be well advised. And we have, I think another possibility is, okay, so dropping the cut score, you've got concerns about the people who didn't quite make it the cut score. If people come close, they don't pass the bar exam, they should be given the chance to show that they truly have the abilities and skills to be lawyers in a provisional system, and then be rated on that. I think that if that's the concern, let's have that opportunity to give them a path in. So I think the current system is troubled. We know that. And there are better, more egalitarian ways to promote diversity, equity, and inclusion.
Well, thank you. I appreciate that, because I'm sure that some of our listeners at home, viewers at home, probably had that question they may have been afraid to ask. So I want to thank our panelists. I think this was a stimulating, exciting panel. It's really august. I feel honored to be part of this. Many thanks, of course, to President Testy and LSAT for co-sponsoring the panel and doing all the technical work that made life so much easier for all of us. We really appreciate that. So let's take a break. The next panel is going to be Pathways to the Profession, Hiring for Law Firms and Corporate Positions. It's going to be moderated by my friend and colleague, Dean Collins. So thank you again for this panel and this great conversation. Thank you so much.
Thank you.